Okay, hi, I'm Meng Fanmo, and today is about the progress report of my business law assignment 1. So firstly, we should analyze about this case. So firstly, we use the IRAC method, and secondly, we should judge that whether it is negligence. And third, we should use legal principle and case law. And finally, we give the conclusion about this case. First, because of the IRAC method, we should describe the issue. And look at this PowerPoint slides, and you can see it briefly describes this case. So Sarah is a customer at Freshmart, and she buys something, and then there's a wet floor, and she injured because of the wet floor, and it caused financial loss and physical pain. So the issue is whether the Freshmart is negligent to Sarah, and how Sarah can sue for Freshmart. Secondly, we use the rule and application to analyze this case. So firstly, we should describe about the concept of negligence. So negligence is omission to do something which is a reasonable man would do, or do something which a prudent and reasonable man would not do. We can also use the case of Blaze versus Birmingham Waterworks to show the concept of negligence. And there's 4 parts of the negligence. If we can prove all of the 4 parts, so there exists a negligence, or we cannot say that it is negligence. So firstly, it is duty of care, and then it's breach of duty of care, and then is causation and remoteness. So the first one is duty of care, according to Donoghue versus Stevenson and Capero Industries versus Dickman. So duty of care is someone have omission to another people, like a driver should make sure that all of the passengers is very safe. In this case, Freshmart is a service organization, so it has the obligation to ensure the consumer safety. It has a duty of care. And then is a breach of duty of care, which we can use the reasonable man test or the case of Nettleship versus Weston. In this case, Freshmart cannot obey the obligation and causes injury. There's a wet floor, and cleaners do not clean this floor, and then it causes Sarah's injury. So it breached the duty of care. It cannot make sure the customers are safe. And the third one is causation. We can use a but-for test. Also, the case of Barnett and versus Clarissa and Kensington Hospital to show it. In this case, we can use the but-for test. If cleaners cleans the floor in time, the injury cannot happen because now the floor is very dry, so it cannot cause the injury for Sarah. And the last one is remoteness. We can use a foreseeability test and overseas tank ship versus more stock and engineering this case. So in this case, every reasonable man can very easily to see that a wet floor may cause a slip or accident. So based on the 4 parts, we can say that Freshmart is liable for the Sarah and it is negligence. However, the Freshmart may make some defenses to Sarah. The first one is about contributory negligence. According to Section 12A of the Civil Law Act 1956, for example, everyone can see there's a wet floor, and you can you cannot use a wet floor. However, Sarah should take the steps of the wet floor, and it causes injury. And you can avoid that to use your eyes. You can see that, right? So because of that, the fresh mart uh, may say that there also has a percentage of liable to the Sarah. And the second one is voluntary assumption of risk. So although you see this wet floor and you also take your steps on it and you walk around, so walk through the wet floor, and it also may cause some liable for the seller. Finally, we should describe the policy consideration. So the first one is setting appropriate plan. There's a crowd place, but Fresh Mart should make sure that the cleaning and maintenance progress should be executed at the appropriate time, like before opening or after the closing. So there's less people, and then it may not cause the accident. And secondly, we should notice the consumer when the cleaning is in progress. So make sure that this sign is set at this place. Thirdly, we can norm the timetable. When the progress is done, cleaners should write a check-in spreadsheet, and it includes the time, item, and evidence, so we can make sure that uh, the cleaning progress is done and the floor is very dry. Finally, we should training the cleaners. If the injury still happen, cleaners must know how to make the emergency rescue and help the consumer immediately. And there's the conclusion. Based on the RAC method, we have a strong evidence can prove that fresh marks constitutes negligence for Sarah. Because of that, it may cause damage to Sarah and face to loss of reputation. To avoid this injury happens again, fresh marks should adjust the cleaning progress and training cleaners. Okay, that's all of this. Thanks for listening.